Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
All right, and welcome once again here to Ask a Lawyer on CP24. As always, John Scholes, your host, is ready to educate you further about employment rights, employment law. We shatter the myths and make you that much smarter in the workplace. Lior Samfiru, employment lawyer from EmploymentLawyer.ca, joining me momentarily. The boss is back, so we'll get to that in just a bit, see what he's got to say over the next half hour. Big show today, employee rights when the business is sold. That'll be the main topic a little later on the show, right? But right off the top, I always give you some contact information. Reach out to Lior and his team anytime. Always invited to call 1-888-861-4555. Ask at EmploymentLawyer.ca is the email you can use anytime. And a website, absolutely free. You don't have to join anything, no login, don't have to pay for anything. Absolutely free, and you can learn so much on your own time. Just lurk around the website for a little bit, called PocketEmploymentLawyer.ca. And a reminder, radio show. We're going to get to some of our phone calls from our radio shows here in just a bit. You can get those across the country, and especially here on News Talk 1010 Sundays at 1 p.m. Please join us, call in, and you might appear on this show, your voice anyway, right? In just a couple weeks from now, so we'll do that. But Lior, we always start off with the week that was. On your end, pal, what is going on?
John, always great to be here. So happy to be talking about employment law and to try to solve as many workplace problems as possible. By listening to the show, people will learn a lot about their rights. We all have rights. We have extensive rights when it comes to our job security, our rights in the workplace. Unfortunately, not everyone knows what those rights are. Well, you're going to know because you're watching the show. On the show, we'll tell you what you need to know, not what your employer says or does or even what your employer wants you to do. We'll tell you what the law says and does for you, whether you've been wrongfully dismissed, mistreated in the workplace, whether you've been discriminated against, constructively dismissed, whether something is owed to you. We'll tell you what you can do to resolve those issues, how the law protects you, and of course, what to do if you're in a difficult situation. But right now, I can also give you additional ways to resolve those problems, and that is by giving you my contact information. You'll get that across the show and on the screen, phones and emails, so you can reach me in the office, so I can actually roll up my sleeves and get to work to help you. But right now, this is the show where you learn about employment law. And I always like to start off with a situation that came across my desk. Now, John, we've talked before on the show about this idea of a fixed term employment agreement. That is a situation where you're working on a fixed term for a specific period of time, 2 months, 6 months, a year. And what happens if your employment comes to an end? Well, our regular viewers will know that if you're on a fixed term employment agreement and you're let go before the end of the agreement, your employer still has to pay you until the end of it, even though you're not working. Well, I had a good example of that in a bit of a different context. I spoke with a university student who had taken a summer job for 3 months for June, July, and August. He was going to go back to school in September. So he started there beginning of June, and 3 weeks later, his employer said, listen, things didn't really work out. We didn't get the funding that we wanted. Unfortunately, we have to let you go. We're not going to pay you any severance. You worked for 3 weeks. So we're just going to wish you farewell, and hopefully you find another job. Well, this individual thought that I guess that made sense. He was upset and frustrated, but he didn't think he could do something about it. But because he watched this show, he called me. And here's how this works, John. He was on a fixed term contract between June and September. That's 3 months that he was going to work. He was let go 3 weeks into this contract. Well, guess what? That employer now has to pay him for the remaining 2.5 months, 2 months and a week. They have to pay him till the end of the contract, even though he's not working, even though they didn't get the funding, even though they had a good reason perhaps to let him go. So that is very, very common. It's common with summer jobs when you're working on a fixed term and you're let go sooner. It's common if you're working as a maternity leave replacement. It's common in any job where you're let go before the end of the contract. If that's what happens, in most cases, you still have to get paid till the end. And that could mean months and months and months of pay. So if you're let go, even more of a reason to call me if you're on a fixed term contract.
Well, as I mentioned earlier off the top of the show, and Lior did as well, we're talking about our radio shows, happen all week. We've been doing these for over a decade across the country, including, as I mentioned, News Talk 1010, Sundays at 1 p.m. Call into the show, ask some great questions. You might appear on this show. Lior, I want to get to our first phone call from the radio show right now.
19 years with a company. I had to take a year off last year to get a new hip put in. I'm 58 years old. I was served with a PIP program, so a performance improvement plan, and they laid out a bunch of markers that I had to hit before a certain date. If I don't get close to those markers, I can be terminated. Whether I will or not, that's coming up, I guess. So I'm curious, what am I entitled to if they say you haven't met your quotas here?
So if you're coming back to work and you're not at full health, you had a medical condition, you're back to work, you're still trying to work your way back to the way you were, your employer has to understand that. You can't be punished because you're still struggling with your health, because you can't do the job exactly the way you used to. So in this case, if his employer imposed metrics on him that are not reasonable because he's not yet at full board, he still needs to be accommodated, well, that's a human rights violation. You can't impose unreasonable metrics. You can't punish someone because they're sick, because they have a disability or a serious medical condition. Can't do that. You have to accommodate them. You have to work with them, and you have to be reasonable. So right off the bat, I have some significant concerns that this person had his human rights violated, discrimination. But beyond that, if he loses his job, even if he doesn't meet those metrics, he is entitled to severance. Again, even if he doesn't meet those metrics, same with you at home. So how do we find out how much he's owed? What does he actually get? We're going to use our severance calculator tool so you can see as well. We're going to go to PocketEmploymentLawyer.ca. Again, PocketEmploymentLawyer.ca, and let's see what the result is here. So this person has been there for 19 years, is 58 years of age. We don't know if a company is going to give him severance, but what we do know, you see that on the screen, that he's owed right around 18 months of severance. 18 months. That's how easy it is. You could do the same thing if you lost your job, or like this person, you're worried about losing your job. Check out PocketEmploymentLawyer.ca to find out what you're owed.
All right, Lior, good stuff. We'll pop into a short break here. On the other side, employee rights when a business is sold. That is a huge topic, especially since the pandemic, so stick with us for that. Lots more Ask a Lawyer is on the way right here on CP24.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
All right, welcome back to Ask a Lawyer here on CP24. John Scholes, your host, and the boss is here with us again this week, Lior Samfiru. You want to reach out any time. That is ask@employmentlawyer.ca, and the phone number, use it, 1-888-861-4555. Okay, time for the main topic for this evening. This one's a big one as well. Employee rights when the business is sold. Lior, I'm going to get to the questions right away. Big one off the top, and that is when a business is sold, do the employees automatically get severance pay? What do you think?
So, John, it's very often stressful and confusing for someone when their business is sold. There's always lots of questions to be answered with respect to job security and what you're owed. So very important that we cover this topic. And usually I get this question first. The one you ask is, well, if my business that I'm working for, they're selling the business, do I get something? Am I owed compensation? Am I owed severance? Well, the answer is you get severance if you lose your job. You don't automatically get a severance package just because the business is sold, but you do get a severance package if that job is gone. If you're going to be out of work because of the sale, you are owed severance. If you're going to continue working, if the buyer has a job for you, you're going to accept that job, you're going to continue working with the buyer, severance is not going to be owed to you. We'll talk about what happens to your seniority in a second. But always, when it comes to severance, the question is, did I lose my job? If you did, severance has to be paid.
So now if that former employee is left high and dry, who pays that severance that they're going to get?
So if you lost your job as a result of the sale, yes, you're owed severance. That could be as much as 24 months' pay, and that severance is owed to you by the seller. Okay, the seller has to pay you that severance, not the buyer, not someone else. The seller has to pay you your full severance, even though they're selling the business, even though they've done nothing wrong, they have to pay you that full severance. And you want to deal with that quickly before the seller shuts down, takes the money, and disappears. So if you know the business is being sold, if you know you're not going to have a job, let's make sure we get your severance right away.
We are talking about employee rights when the business is sold on the show. That's our main topic. Third question is, what happens to employees' length of service now if they're not let go, if they continue working with the new buyer?
So generally speaking, if you're going to not lose your job, if the buyer has a job for you, you're going to continue working with the buyer, doing your work, well, they inherit your service. They inherit your service, meaning that on day one, you're not a new employee. You have the same amount of time with the new company that you had with the old company. And of course, that is important because your seniority counts when it comes to your severance. So if the buyer down the road decides to let you go, because they inherited your service, they now have to pay your full severance based on that service. So you may have only worked for the buyer for 1 year, but you had 7 years with the seller. Well, you're now an 8-year employee, and that's going to be what counts when it comes to your severance package.
We'll call this one the red flag question, Lior. So now what if the new owner wants the employee who's still there to sign a brand new employment contract?
So, oftentimes we see with the sale of a business, the new company may offer you a job. The seller or the buyer may say, yeah, you have a job, but we need to sign this new employment agreement. Always be very careful with that. Because as I said before, they inherit your service, but they don't inherit it if you sign an employment agreement that says, no, we're not inheriting it. So you can give up your service through an employment agreement. It can also have a termination clause that limits your future severance, limits your rights. So be very, very careful, especially in a sale of a business with that new employment agreement. If you're asked to sign it, let me see it first. If you're not asked to sign it, if you just say, hey, come on board, you don't need to sign it, that's a good thing. Do that. But before you sign anything, let me see it.
How about the flip side of that, Lior? You get the employee who's decided for whatever reason not to continue. Maybe it's a good time, a perfect time to go back to school. Maybe they got another job. They want to start their own business. I don't know. Whatever the reason, do they still get anything? Do they get anything at all?
So we know that if you lose your job as a result of a sale of a business, you get your severance package. Of course, it could be as much as 24 months paid. But even in a situation where you are offered a job by the buyer and you decide not to take it, you still could get your full severance. If you have a good reason not to accept the job with the buyer, maybe it's a different job responsibilities, different location or different pay. So you have a good reason. Well, you're still going to be owed your full severance if you refuse. If you don't have a good reason, you just, hey, I'll take this opportunity to retire, then you still get severance, but not your full severance, just your minimum entitlements. So yes, even in a situation where you decide not to accept the job with the buyer, severance may absolutely still be owed, so you want to give me a call.
I mentioned that website earlier in the show, Lior, that is EmploymentLawyer.ca. On that website, you can search around for a radio station close to you, nearby in your town, where you can catch our either half-hour or hour-long radio shows. And we always say, give us a call, be that third voice on air, and join the show. You can do that anytime, including News Talk 1010 right here in the GTA, Sundays at 1 p.m. I'd like to play those phone calls here, Lior, as you know, and talk about them. Phone call number 2 is coming right now.
I had a soft tissue injury. I was off for about a month, did some, rehabilitation, went back unmodified, still unmodified, supposed to go back next week, but I don't feel like I'm pain-free and comfortable enough to go back to regular duties. How do I go about remaining on my modified duties because I'm not ready to go back to that?
So that's actually quite straightforward. If you need accommodation, if you're not able to go back to work the way that you used to without help, all you need is a doctor's note. You need a doctor's note to say, I need accommodation. A doctor's note to outline hopefully what those accommodations are. Do you need light duties, not to lift things? Do you need reduced hours? Do you need to work from home? Whatever that accommodation is, it needs to come from a doctor. An employer has to accommodate you in that situation. They have an obligation, but the duty to accommodate is triggered by you providing a doctor's note. It's not going to be enough for you, the employee, to say, hey, employer, accommodate me, I need help. That's not enough. You need a doctor's note. If your employer doesn't comply with your doctor's note, that could be a huge issue. That could be a human rights violation. It could be a constructive dismissal. That's exactly when you have to call me. But it all starts with you getting that doctor's note.
2 great phone calls so far, Lior. Want to see if we can go for the hat trick after a short break. We'll get to that and lots of your emails and more questions. Still got more time to go, so stick around. We'll do that on the other side right here on Ask a Lawyer on CP24.
You have have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back. Thank you so much for sticking around here to Ask a Lawyer on CP24. As always, John Scholes and employment lawyer Lior Samfiru, who's doing all the heavy lifting on the show again this week. Phone call number 3, again, reminder you want to reach out anytime, 1-888-861-4555, ask@employmentlawyer.ca. And the website, free, anonymous to use, for you anytime, pocketemploymentlawyer.ca. Radio shows across the country for a very long time, including News Talk 1010 Sundays at 1 p.m. Lior, phone call number 3 for us to talk about is coming up right now.
I was working for a company for about 6 years, and I was just let go on Monday. They gave me an email stating that I had 2 weeks in lieu of notice and severance pay of 2 days for each year of service. And I was just wondering, is that enough? I'm 53. I just turned 53.
Well, John, from the sounds of it, you're shaking your head, but from the sounds of it, this person works for a federally regulated employer. Why do I say that? Because a federally regulated employer, often there's this misconception, this nonsense that you're only owed 2 days per year of service. So, we're talking banks or trucking companies, telecommunications that are federally regulated. Well, no, that's nonsense. Whether you work for a federally regulated employer, provincially regulated employer, well, any employer, you're owed a heck of a lot more severance than that, and your entitlements are going to be the same. So this person is owed much, much more than the 2 days per year of service that his employer said that he's owed. How much is he owed? I'm going to show you, of course. We're going to go back to our severance calculator. You can find it at pocketemploymentlawyer.ca. You see that on the screen right now. And we're going to plug in the information because we want to know the truth. We want to know the real number that this person is owed. So this person, as a supervisor, been there for 6 years, not 4 weeks, which is 2 days per week or whatever it is that per year that the company wants to offer him. He's owed 8 months of severance. 8 months. Okay, that's how much he's owed, and that's, by the way, how easy it is to find out how much you're owed at pocketemploymentlawyer.ca. So let's be very clear. If you lose your job, it's not a week per year of service. It's not 2 weeks per year of service, 2 days per year of service, or anything else. It's based on several factors, and we have a tool for you to find out right now how much you're owed. Again, pocketemploymentlawyer.ca.
All right, let's grab a viewer email here, Lior. We've still got some time, and it goes like this. What's the difference between a termination and a layoff? I've been technically laid off. Am I still allowed to ask for severance pay, or is an employer within their right to say no?
So let's break this down because there's a lot of confusion about termination, layoff, fired. Let's break this down. When it comes to termination, the law recognizes only 2 types of termination, a for-cause termination or without cause termination. For cause means you've done something terrible, something so bad that you can be let go without severance. That's the only time you can be let go without severance, if you did something terrible. And it doesn't matter what the company says, it matters what you actually did and what the law thinks about it. So making a mistake, for example, it's not a termination for cause. You're still owed your full severance. If you didn't do something terrible, that's what we call a termination without cause. Company can let you go, but they have to pay your full severance. So those are the only types of termination. Now, layoff is a term that we use for what we call a temporary layoff. If the company is saying, we're not letting you go, we're just putting you on a temporary layoff, hopefully we'll call you back at some point. Well, guess what? Company does not have the automatic right to put you on a temporary layoff. If they do, you have a choice. You can choose to accept it and wait home and see if they call you back. You can do that. But the second option is you can consider that temporary layoff to be a termination. It's up to you. And if you consider it to be a termination, you can require your employer to pay you your full severance. It's not up to the company. They don't get to decide. The employee gets to decide. So in a temporary layoff situation, if you don't want to stay, you don't want to wait, you just want to move on and find another job and not be in limbo, you can consider that a termination and get severance. If that happens to you, if you're put on a temporary layoff, or if you lost your job for any reason, very important to give me a call.
As you know by now, many different ways to join the show here and join Lior when he's doing his thing. You can do so as well through the live stream. That's on Facebook and YouTube. We'll give you more details on that on the other side of the break and get to a question from the live stream as well, right here on Ask a Lawyer and CP24. Hang on.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back to Ask a Lawyer here on CP24. I mentioned just before the break, live streaming on Facebook and YouTube. Join Lior anytime you'd like. Ask some questions. stlawyers.ca is how you do that. Here's a question, Lior. Let's get to it. Yesterday, my boss fired me in a short text after I told him that my LTD claim was denied for a second time, and I'm still not able to return to work. Can he just fire me like that and through a text?
So the issue here is not the text so much as you cannot be fired because you're sick. And it doesn't matter if you've been denied long-term disability. Whether or not you get long-term disability has nothing to do with your ability to work. The only thing you need to be off work is a doctor's note. That's it. So in this case, this could be a human rights violation if the company says, well, we don't believe you're disabled, we don't believe your doctor's note, so we're going to let you go. Of course you're going to be owed severance, a significant amount of severance. But that can also be a human rights violation. So remember, to be off work, all you need is a doctor's note. If your company does anything to you, call me. With respect to your insurance company, your disability insurer, yes, they're entitled to get additional information. But if they too deny you, well, the good news is we have a whole team at my office dealing exclusively with this issue. So if you've been denied your disability coverage, you should be getting it. You should be getting it potentially till the age of 65. Give me a call. I'll connect you with one of my colleagues. I will take care of it.
And with that, we are just about out of time. Thank you so much for your contribution if you made it on air with us. If not, you can join us again on the radio show, News Talk 1010, Sundays at 1 p.m. Call into the show. You may appear on this show as well. And to reach out to Lior and his team anytime, that phone number, 1-888-861-4555, ask@employmentlawyer.ca. And the website, free, anonymous. Use it anytime you would like, pocketemploymentlawyer.ca. And for all other questions and information, cp24.com/askalawyer. We'll catch you next time.